Title 14, Quasi Offenses, Article 365, Imprudence and Negligence. Quasi offenses punished: 1. Committing through reckless imprudence any act which, had it been intentional, would constitute a grave or less grave felony or light felony. 2. Committing through simple imprudence or negligence an act which would otherwise constitute a grave or a less serious felony. 3. Causing damage to the property of another through reckless imprudence or simple imprudence or negligence. 4. Causing through simple imprudence or negligence some wrong which, if done maliciously, would have constituted a light felony. Note: imprudence or negligence is not a crime itself. It is simply a way of committing a crime. It becomes punishable only when it results in a crime. The rules for graduating penalties, under Art. 64, based on mitigating and aggravating circumstances, are not applicable to offenses punishable through criminal negligence. Note: qualifying circumstance: failure to render immediate assistance to the injured party. This qualifying circumstance must be distinguished from the punishable omission under Article 275. Note: if the danger that may result from the criminal negligence is clearly perceivable, the imprudence is reckless. If it could hardly be perceived, the criminal negligence would only be simple. Criminal negligence is only a modality in incurring criminal liability. This is so because under Article 3, a felony may result from dolo or culpa. Therefore, even if there are several results arising from only one carelessness, the accused may only be prosecuted under one count for the criminal negligence. Otherwise, double jeopardy would arise. Notes: elements of reckless imprudence. The offender does or fails to do an act. B. The doing of or the failure to do the act is a voluntary. C. It is without malice. D. Material damage results. E. There is an excusable lack of precaution on the part of the offender, taking into consideration 1. His employment occupation, 2. Physical condition, 3. Degree of intelligence, 4. Other circumstances regarding the persons, time and place. Note: 1. Reckless imprudence resulting in homicide. 2. Resulting in physical injuries. Note: inexcusable lack of precaution. Factors to be considered in determining inexcusable lack of precaution. 1. Employment or occupation. 2. Degree of intelligence and physical condition of the offender. And 3. Other circumstances regarding persons, time, and place. Note: violation of a rule or regulation or law is proof of negligence. But negligence cannot be predicated upon the mere fact of minority or lack of an operator's license. The penalty next higher in degree is imposed if the offender fails to lend on the spot to the injured party such help as may be in his hands to give. Notes: Carrillo v. People, 1994. The gravamen of simple negligence is the failure to exercise the diligence necessitated or called for by the situation which was not immediately life-destructive but which culminated, as in the present case, in the death of a human being 3 days later. Medical malpractice, which is a form of negligence, consists in the failure of a physician or surgeon to apply to his practice of medicine that degree of care and skill which is ordinarily employed by the profession generally. Under similar conditions, and in like surrounding circumstances, Garcia Ruda v. Pascasio, 1997, res ipsa loquitur, the fact of the occurrence of an injury, taken with the surrounding circumstances, may permit an inference or raise a presumption of negligence, or make out a plaintiff's prima facie case, and present a question of fact for the defendant to meet with an explanation. Ramos v. CA, 1999. Requisites for the application of res ipsa loquitur. 1. The accident was of a kind which does not ordinarily occur unless someone is negligent. 2. The instrumentality or agency which caused the injury was under the exclusive control of the person in charge. And 3. The injury suffered must not have been due to any voluntary action or contribution of the person injured. Note: ordinarily, only physicians and surgeons of skill and experience are competent to testify as to whether a patient has been treated or operated upon with a reasonable degree of skill and care. However, testimony as to the statements and acts of physicians and surgeons, external appearances, and manifest conditions which are observable by anyone may be given by non-expert witnesses. Reyes v. Sis of Mercy Hospital, 2000. Illustration: People v. Carmen, 2001. It would appear that accused appellants are members of a cult and that the bizarre ritual performed over the victim was consented to by the victim's parents. With the permission of the victim's parents, accused appellant Carmen, together with the other accused appellants, proceeded to subject the boy to a treatment calculated to drive the bad spirit from the boy's body. Unfortunately, the strange procedure resulted in the death of the boy. Thus, accused appellants had no criminal intent to kill the boy. Their liability arises from their reckless imprudence because they ought that to know their actions would not bring about the cure. They are, therefore, guilty of reckless imprudence resulting in homicide and not of murder. Art. 365 of the Revised Penal Code, as amended, states that reckless imprudence consists in voluntarily, but without malice, doing or failing to do an act from which material damage results by reason of inexcusable lack of precaution on the part of the person performing such act. Note: compared to intentional felonies, such as homicide or murder, what takes the place of the element of malice or intention to commit a wrong or evil? The failure of the offender to take precautions due to lack of skill, taking into account his employment or occupation, degree of intelligence, physical condition, and other circumstances regarding persons, time and place. The elements of reckless imprudence are apparent in the acts done by accused appellants which, because of their lack of medical skill in treating the victim of his alleged ailment, resulted in the latter's death. As already stated, accused appellants, none of whom is a medical practitioner, belong to a religious group, known as the Missionaries of Our Lady of Fatima, which is engaged in faith healing. Note: Ivler v. Modesto San Pedro, 2010. The accused got involved in a car accident for which he was charged with 2 separate offenses: RI resulting to slight physical injuries and RI resulting to homicide and damage to property. He was convicted of the first offense and he wanted the second information quashed on the ground of double jeopardy. The court held that the reckless imprudence is a single crime and the consequences on persons and property are material only to determine the penalty. The conviction or acquittal of such quasi-offense bars subsequent prosecution for the same quasi-offense, regardless of its various resulting acts. The law penalizes the negligent act and not its result. Note: Rafael Reyes Trucking v. People, 2000. Much of the confusion has arisen from the common use of such descriptive phrases as homicide through reckless imprudence, and the like, when the strict technical sense is, more accurately, reckless imprudence resulting in homicide, or simple imprudence causing damages to property.